you worked hard to build up assets. And once you're gone, you want those assets to go to who you want them to go to. Your kids, your grandkids, your charities. But sadly enough, there are things that happen that go bump in the night, mistakes that are made where your assets don't wind up where you intended, or they create problems for the beneficiaries that you want to receive them. We're going to walk you through how assets flow upon your demise on Consider This Program today. Well, good morning and welcome back to Consider This Program. I'm your host, Joe Clark.
And I'm Daren Hardesty.
Happy to have you along. Daren is one of our senior advisors in the Anderson and Fisher's office, primarily also Brownsburg and Lafayette. Occasionally, happy to have you along, Daren. We are talking about, well, the whole theme for the show is Happy Halloween.
Mm-hmm.
So we have our foster kids now, so I'm sure I'll be trick-or-treating sometime. Yeah, and you've got your 3 little kids, so I'm sure.
Oh, yeah.
I'm sure at some point in time I've already begun to buy costumes.
Oh, don't forget the pumpkin patch. That's part of the experience, too.
There is a pumpkin shortage, allegedly, here this year.
Well, I was at the pumpkin patch I was at this weekend, which was a ton of fun, by the way, but plenty of pumpkins to be had still. So
did not appear to be a shortage.
Get them while they last.
All right, there we go. Well, and you know the day after Thanksgiving, I always make stuffed pumpkin.
Ooh.
So it's looking forward to that.
Yeah.
Looking forward to that. All right. How assets flow. So you coming back from the grave just to check out the world, to see what happened after you're all said and done. Mm-hmm. Make sure that all the dollars went to where you want them to go. Daren, what happens?
So a lot of our families, and then especially the new families that come in, there's a lot of them that come in. I can think of multiple friend meetings that they come in and we ask them about estate documents. We ask them about how they want their assets to pass, and they tell us, well, I've got my will. I got my will set up and we're good to go. And I think that's a common misconception that a will take care of everything that you need. And you know what? Some people, it may. There are situations, if you've got everything else lined up, that a will is perfectly capable of making sure that everything in your estate passes the way that you want it to. If you're intending to leave anything behind, though, you want to make sure that you know that a will may not be the best thing that you need to have to make your beneficiaries' lives better.
I always have to say this. We're not attorneys. Don't
Yes.
play one on TV or radio.
Yes.
We do have an attorney on our team for this very reason.
Yes.
And we'd still recommend that you get your outside counsel. But
Absolutely. But we want to make sure you, if anything, that you know the general rules. So beneficiary designations is something that you can apply to almost every one of your accounts. And if you live in the state of Indiana, that even applies to your home. It's called a ladybird deed or a transfer on death deed. But the reason why I'm bringing that up is that a beneficiary designation is going to supersede whatever the will says. So if I want to leave, if I put in my will that I'm leaving X, Y, and Z to my kids, but my beneficiary designations say different, well, it doesn't really matter what the will says at that point because the beneficiary designations are going to pass by law before the will becomes an issue or becomes enforced and actually is enacted. So making sure that your beneficiary designations are lined up accordingly. If you've done that, and then everything else you can inside of your will or whatever your estate documents are, it's going to control everything that does not have that designation applied to it. So in our practice, and what we believe makes sense for most people, and again, we're not attorneys, and this isn't legal advice, but in our practice, we see no reason that anybody should technically have to go through probate. Personally, I have family that had a good sized estate. Everything was in a trust, and the trust is funded. It was funded by multiple things: the home, the farm, investment accounts, everything except for the bank account. And there was about $100,000 in the bank account. Well, guess what? My family's going through 9 months of probate over a $100,000 account, which is a very small fraction of whatever the entire estate was. And it's just a headache that you're haunting your kids from the grave. It's something that you don't have to go through if you've checked all the boxes and make sure that everything is lined up accordingly. So that takes me to probate. A lot of people ask, what is probate? And probate is essentially, it's the 9 months, depending on the size of the estate, but about 9 months for most people, where the attorneys need to make sure that everything inside of your estate is closed, passed on to the correct people based off the directives of the will, or institutions, not just people. But that probate period, there's fees that have to be paid to the attorneys and expenses that have to be paid, and there's different things that in my mind, if I'm thinking about it, the last thing I want my wife or my kids to go through is dealing with or sitting in a required attorney's meeting, being billed for that while they're trying to grieve my death.
So your wife could have to go through probate over you?
Yes.
How does that happen?
So anything that is above $50,000 in the state of Indiana, and this is subject to change, but anything above that inside of my estate is probatable as long as there's no beneficiary designation attached to it, or if it's not funded by a trust that I own. So it's essentially, it could be, and you may have an attorney that if it's a little bit over 50,000, you might be able to find a way to get that taken out. But if you have anything, especially your home, that typically is the one that people forget about. If it's worth more than 50,000, it is required by law to go through probate to make sure that everything is passed to the correct people.
So think about a second marriage, or a spouse passes, and you've still got your old spouse's name on it,
Mm-hmm.
and you've got a new spouse that you intend to give the house to, but you forgot to change the deed.
That's something. When we go through our 5 critical elements, when Joe and I prep for a meeting, the 5th of those is your estate or legacy plan. And no matter what, however complicated your estate is and things that we need to look into, and a lot of our families we take care of, there's some complications and things that are a little bit unusual for the normal person. But the easiest thing to remember, and every time I get to that estate planning part of the prep, is check the beneficiaries, make sure that they're up to date, because that's such an easy thing to miss. And you just want to make sure, hey, is this all in order with my wishes? And it's not a fun thing to think about, but it's also something that it's easy to miss, because it's like the simplest things are the easiest things to forget sometimes.
Here's how significant this is. And, I've already got a raspy voice today. I apologize. But if I choke up a little bit, I lost friends on 9/11. And we didn't have the electronic systems that we have today, even in those big Morgan Stanley buildings and everything
Mm-hmm.
else, right? And so most of the beneficiary designations, you would go to work, you would sign your beneficiary designation, right? Vicky's got it in your file, right? The towers go down, and the judges didn't know what to do, right? So with a 401k, unless your spouse is signed off, they have to be the beneficiary.
Mm-hmm.
But your IRA could be your brother, could be your kids, could be your best friend, it could be anybody, right? Your life insurance, your IRAs, any of that stuff, you could leave to anybody you wanted. And the courts just made a unanimous ruling that if you were married, it went to your spouse, right? And, so that was lesson number 1 that we learned. Lesson number 2 was about 68%. And I think the last time I saw this number was in 2010 or 12, one of those 2 years. Still teaching at Purdue. But 68% of beneficiaries are dead. That comes from the insurance industry. And you may ask, how do they know that? Because, they have the beneficiary forms and they know what death claims they've already paid.
Yeah.
Right. And it's not their responsibility to call you up and say, hey, right, you need to have this, this changed or done. Right?
Yeah.
So beneficiary forms are one of those things that you need to check and you need to keep on file. We keep it on file for you, but you need to keep it on file. Right. So we want to make sure that your employer you've got a copy of the form so we can prove that this is who the beneficiary is in case their office burns down or blows up or something like that.
Well, and you did a segment that I encourage everybody to check the podcast with Bill Harris. And he brought up a really important point. What happens a lot of times if you transfer or if your account switches custodians, which happens a lot, if you're a 401k provider and your custodian is with this company, and then your plan sponsor decides, hey, we're going to change it. A lot of times the beneficiary designations don't travel. So what people do in those situations, we actually have a phone call I'm going to be making here in a few days where they have to make a decision. If the plan sponsor changes, a lot of times people have the option to roll that money into an IRA, do nothing, just leave it in the 401k plan as it switches the custodian, or they can actually take a lump sum and pay taxes and potentially penalties. Most people do nothing. They just say, well, I'm just nothing to worry about. And so they switch plans. They think everything's the same. Nothing's changed, but the beneficiary designation doesn't travel. And it's the easiest way to make sure that your estate is in order. And going back to a topic we've covered many times, but not every beneficiary is the same. So while it made sense 10 years ago for your 2 kids to be 50-50 beneficiaries of your IRA, keep in mind that's going to be 10-year rule at this point. and it's going to be completely taxable at your kid's marginal tax bracket. Now 10 years has passed. One child is making a significantly higher income than the other, and all of a sudden now 50-50. Well, it's not necessarily after taxes a true 50-50 split. And if your intent is to make sure your kids get the as close as possible net amount that's the same after taxes, well, you might need to rearrange your beneficiaries to line up to those wishes. And it's something that every year, double check, is it in order based off of what you currently want?
So the point in summary is if you want to use a will and go through probate and put your family through that and haunt them, you can do that. You can use a will, depending on your assets, and usually put extensions on the asset, TOD, transfer on death, beneficiary designations. You can do it for your house. You can do it for just about everything. There's ways to get around. You can certainly do it for bank accounts and brokerage accounts. There's ways to get around probate most of the time. It's a little bit more difficult, I think, with cars than it is with other things.
Sure.
But you can do that. So you may or may not need a trust. That's not our job. What I do is bring people in when we talk about our FEG trust division. We can be successor trustees. And so we sit down and have a conversation, and I go over essentially my trust with you and say, here are the things that I've considered and that I think are important. And then you can kind of say, okay, I think this matters. I think it doesn't. And then we send you off to your counsel, and your counsel puts the trust together, and voila, there we go. And we're able to work together when something happens to you. And you're going to hear me talk about our trust division for years to come. It is one of the things that drives me, primarily not why we're capable mentally and physically, not when we're dead even, but it's what happens in between when somebody needs to care for us and we don't have necessarily that financial expert to be able to do that.
Yeah.
So that's where the FEG trust division comes into play. You can give us a call at 800-928-4001. Find out more at our website at yourlifeafterwork.com. And while you're there, get signed up for a Next Steps meeting. We look forward to meeting you. We'll spend 90 minutes with you, give you things to consider today, things to consider in your future, and if we choose to partner together, what FEG will do for you, and we'll put it into writing. Appreciate your time. Hope you're having an outstanding week and a happy Halloween. Again, it's 800-928-4001, yourlifeafterwork.com.